Hello, my name is Van Smith, managing partner here at Smith Strong Law Firm in Virginia, and today I'd like to talk to you about Virginia custody modifications and the material change in circumstances standard, very briefly. The Court of Appeals in 2024 ruled recently in Garrett v. Hanna, a case where they transferred physical custody of a minor child to the father after finding, one, there was a material change in circumstances, and two, the best interest of the child warranted, and they affirmed the circuit court ruling for custody to be transferred to the father. And they cited that though the case had previously been litigated in Colorado, that the father had petitioned the court based on the child's, quote, mental and emotional health having deteriorated. And the evidence showed that since the last order, and so it's very important, the material change has to have occurred after the last order. So in a two-prong test for Virginia custody cases, the first prong is material change since the last order, and two, that material change warrants a change based on the best interest of the child standard. And so here they found since the last order, there was a material change through anxiety and depression and overall disorder as established by a counselor. So they had third-party corroboration with an expert. And so the father testified that the child would often become ill, that the child appeared healthy and happy while in his care. And the father's circumstances had changed and he had relocated to a new state. And so the Court of Appeals found there was a material change, and they also took note of the mother in this case's alleged interference, quote, with visitation, providing credible evidence supporting the modification. So the court found there was anxiety established by a third-party expert. The court found that the alleged facts there that the court affirmed in their order was that mother was interfering, as they described it, with visitation, and that there was a material change since the last order, and they transferred custody to the father. In this case, meaning the father and the child moved to a different state. These are very, very tough cases, and we have them here at Smith Strong, relocation cases. We live in a very transient society, and jobs are moving us all over the country, it seems. And so oftentimes these custody cases with relocation consequences require a material change to rise to the level to meet the standard of changing a child's life and moving them out of state. And so then, is the change warranted since the last order? Does it meet the best interest of the child or children? And there are items there in the statute that lay out the best interest. Allegations like emotional harm, interference with visitation, significant changes in the parent's situation can all support a modification. So in this case, they had mental health concerns, they had interference by mother in the visitation process, and father's ultimate relocation for a new spouse and new job. And so then it transferred primary custody to father, and he was able to move out of state. Very interesting case, but not an uncommon one now in Virginia. And so if you're facing a custody or visitation case, in particular one with relocation consequences, very important to plan early, very important to have your ducks in a row, and oftentimes involving experts to support the material change standard needed to support a relocation. We look forward to helping you in a Smart Start comprehensive case preparation meeting. That first meeting of a case of that type typically takes about an hour and a half. And so give us a call and we'll set up that Smart Start comprehensive case preparation meeting that you will truly need to get started on the right foot in this area of the law. Thank you so much for your time, and we look forward to assisting you.